This isn't just another traffic stop. This is a mother facing a third-degree felony, staring down a decade in prison for her fourth DWI. And the most chilling detail, her two young children were in the car with her. Her name is April Diaz, and she's about to plead her case in a virtual courtroom where the stakes couldn't be higher. We're about to witness her lawyer pull out every stop, painting a picture of a struggling single mom pushed to the brink by COVID and a messy divorce. But the judge sees things differently, delivering one of the coldest reality checks you'll ever hear. And just when you think the gavel is about to fall and seal her fate, a shocking twist reveals that this hearing is just the tip of the iceberg. A hidden warrant and a brand new charge are waiting in the wings, and her day in court is far from over.
I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine to be probated, and the state recommends community supervision. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 10 days in the Bexar County Jail, 100 hours community service restitution, DWI intervention, ignition interlock for half the term, parenting classes, $65 restitution for blood tests, and 180-day Texas driver's license suspension. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
I had put guilty. I'm not too sure what I was supposed to put underneath in that.
All right.
Drop down.
Defense, is she pleading guilty or no contest?
No contest, Your Honor.
All right. Your attorney says that you're pleading no contest. Is that correct, Ms. Diaz?
Agreed.
Is that correct? Yes or no?
Yes, ma'am. Yes.
All right. So the defendant has entered a plea of no contest to the charges. State any evidence to support the defendant's no contest plea.
State offers State's Exhibit 1 and all attachments.
The court will accept into evidence State's Exhibits 1 and attachments.
The defendant, April Diaz, has just entered a plea of no contest. This is a crucial strategic move. It's not an admission of guilt, but it functionally allows the judge to find her guilty based on the evidence presented by the state, which in this case is a package of exhibits the judge is now reviewing by pleading no contest. A defendant avoids arguing the facts of the case and moves directly to the sentencing phase. This is often done to avoid a drawn-out, costly trial or sometimes to prevent the plea from being used against them in a related civil lawsuit. Now the real battle begins. With guilt established, her defense attorney's only job is to fight for the most lenient sentence possible. The prosecution has laid out its recommendations, including jail time. The defense is about to make a desperate plea to keep this mother out of a prison cell.
And the court will review the same. Court has reviewed State's Exhibits 1 and attachments. Based upon State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
All right. Anything you wish to say on behalf of your client?
Judge, my client is in agreement with the state's recommendation. The only item outside of the agreement that my client is asking the court to take into consideration is the 10 days in the Bexar County Jail. I understand that sanction is statutory and we've discussed it, but my client is asking for the court to take into consideration. She has had the ignition interlock, I believe, since the inception of this case, which was, I believe, last May. So a little over a year that she's had the ignition interlock. She has been in compliance with that. The court is well aware that she had.
This is the classic appeal to mercy. The defense is building a powerful narrative of sympathy. They're highlighting that April Diaz is a single mother to two young boys, ages 11 and 6. They emphasize that she moved away from her entire support system, her family and ex-husband, and that imposing jail time would create an immense financial and logistical burden. The lawyer is trying to frame this not as a choice made by a reckless individual, but as a consequence of her difficult circumstances. She's had an ignition interlock on her car for over a year. She's working, and she's trying to hold her family together. The question now is whether this narrative will be enough. The judge is weighing the sympathetic story of a struggling mother against the cold, hard fact that this is a felony DWI where children were endangered.
Minor children in the car. The two children are her two boys. They're 11 and 6. CPS was involved at the beginning. It was a family-based case. It never went legal. They offered services. My client was in compliance, and the two boys are with her. So she is a single mother. She's working right now. She works with Aetna Medicare. But again, Your Honor, she's a single mom. She moved from San Antonio away from all of her family and ex-husband. So the imposition of that sanction would just put her in not only a financial burden, but she doesn't have any family members with regard to the two children. So she's asking the court for any alternative sanction, whether that be the GPS monitor or house arrest or whatever whatever else the court deems appropriate.
Okay. Does she live in Bexar County or no?
She does.
The judge just handed down the sentence, and it's a perfect example of a legal tightrope walk. April Diaz has officially dodged a jail cell for now. She was sentenced to 4 years in prison, but that sentence is suspended and probated. This means she won't go to prison as long as she successfully completes 4 years of community supervision or probation under a mountain of strict conditions. The judge even gave her a choice: 10 days in jail or 20 days on a GPS monitor, an option she immediately took to stay home with her kids. She's been given a lifeline, but it's a fragile one. She has to complete DWI intervention, parenting classes, and pay fines, and an ignition interlock will be on her car for 2 full years. This isn't a victory, it's a deferred failure. One slip up, and that 4-year prison sentence becomes very, very real.
Okay. All right, Ms. As far as the 10 days in the Bexar County Jail, the court usually, because of the circumstances involving the health crisis, the court usually gives defendants an option. You can either do 10 days in the Bexar County Jail as a condition, or either you can do GPS for 20 days and you'll be allowed to work. So that will be up to you, Ms. Diaz. Could you unmute yourself and let me know which one you would prefer?
Yes, Judge. Could I, because I do work remote, I do work from home, and it is summertime, I would be greatly appreciative and humbled if I could just do the GPS 20 days.
Okay. All right. This is what the court is going to do. Sentence you to 4 years in prison, suspended and probated for 4 years, $1,500 fine, probated, 100.
The judge has just opened the floor for the defendant herself after laying out a long list of conditions, including mandatory AA meetings and random probation officer visits. She asks a simple question: is there anything else that you need from the court in order to be successful? This is a critical moment. It's April Diaz's one chance to speak directly to the person who holds her freedom in her hands. Will she offer a simple, remorseful, "No, Your Honor"? Or will she use this opportunity to explain herself, to give context to her actions, and to try and garner some final ounce of sympathy? What she's about to say will completely reshape the tone of this hearing, prompting a truly unforgettable response from the judge. Let's listen to what she has to say.
Hours of community service restitution, or you can pay $7.25 per hour to the San Antonio Food Bank, DWI intervention course, ignition interlock for half the term, parenting classes. If she completed parenting classes through CPS, then she can provide documentation of that, and that will be acceptable. $65 restitution for blood testing, 180 days Texas driver's license suspension, 10 days in the Bexar County Jail. You can do 20 days GPS in lieu of the 10 days in the Bexar County Jail for medical.
That was the moment the hearing pivoted from a legal proceeding to a stark life lesson. April Diaz gave an emotional speech framing her actions as a result of the pandemic, losing her job, and the stress of a custody battle. She positioned herself as a victim of circumstance who has since climbed back out and fixed herself up. But the judge was having none of it. In a calm, cutting tone, she delivers a brutal dose of reality. People are not making mistakes with their life. They're making choices. Sometimes they're making bad choices. So you've got to start making good choices. This single statement completely dismantles the defendant's narrative. It dismisses the excuses and firmly places all accountability back on April Diaz. It's a powerful, cold, and calculated reminder that in the eyes of the law, circumstances don't erase personal responsibility.
Purposes, well, based upon medical purposes, and you are allowed to work while on GPS. Ms. Diaz, have you had any type of treatment? And when I say treatment, I mean drug treatment for alcohol.
Yes, ma'am. I did successfully complete an outpatient treatment here in San Antonio last June, I'm sorry.
Okay, what type of treatment was that? What was the name?
So I did outpatient treatment at the Alamo Center here off of 5018 San Pedro. I have my certification right here with Miss Nancy Chandler.
Okay. So I'm going to ask for proof of completion of outpatient treatment.
Okay.
If not provided, then outpatient treatment with probation. And let me ask you, is there any type of follow-up with them? Are you doing NA meetings, AA meetings? What are you doing?
I do, yes, ma'am. I have done some Zoom AA meetings as well. And then I do personally keep in touch with Miss Nancy Chandler as well. We talk on the phone once a month, just about. She's a really great person.
All right, I'm going to ask for AA meetings 2 times per week.
Okay.
There's to be regular Zoom reporting or in person. So what that means is if your Zoom doesn't work, then you have to report in person.
Yes, ma'am.
And I'm going to ask for a field visit 1 time per month, random. And we can do regular UA. Is there anything else that you need from the court in order to be successful, Ms. Diaz?
Your Honor, with all due respect, I know the severity of my actions, and I know the mistake that I made. Like I explained to my lawyer, Ms. Acevedo, it was right when COVID had hit, and I just lost my job, and my ex-husband was threatening at that point to take custody of my boys, and it was just the first time that I've had downtime since divorce where I've been able to just sit back and be by myself, and it was not a good time for me, as a lot of people around the world. So I know what I went through personally, mentally, and climbed myself back out of there and got on the ball and fixed myself up and took care of business mentally, emotionally, and I'm still doing that. And
Just when you think it's over, the screen cuts to a new scene. The defendant is back in front of the same judge, but something is very different. The casual tone is gone, replaced by the stark reality of a new legal crisis. It turns out April Diaz had an active warrant for her arrest this entire time. We are now jumping forward to a completely separate hearing regarding that warrant. All the progress she thought she made, all the conditions she just agreed to, are about to be overshadowed by a brand new allegation. She has allegedly violated the terms of her community supervision by picking up yet another DWI in a different county. The first hearing was about her past. This one is about to decide her immediate future.
making sure that I stay on track, especially for my children, because they're my top priority.
okay, all right, we lost your video.
Oh, sorry, I had
That's
an
okay.
incoming call. I'm so sorry.
Good luck to you. And remember, this is what I tell everybody. People are not making mistakes with their life. They're making choices.
Yes.
Sometimes they're making bad choices. So you've got to start making good choices, okay?
Yes, you're absolutely correct, and I agree with you 100%. And I appreciate your graciousness today, Your Honor.
Oh, thank you so much.
Okay, she'll be in the middle.
Oh, is she currently without a bond?
Yes, Your Honor.
So does she have a warrant?
Yes, she does, Your Honor.
All right, so Ms. Diaz has a warrant.
I've heard-
Where's,
Oh, Your Honor, I had spoken to Satellite this morning, so I am prepared to walk her to Satellite if you're inclined to set a bond this morning.
Okay. All right, court is calling 2021 CR 2312 State versus April Diaz. Could I have parties announced for the record for the state
We're on the record. Your Honor.
defense?
Justin Vouch, Your Honor.
And are you Ms. Diaz? All right, defense, you are here requesting a bond, is that correct?
Yes, Your Honor.
All right, defendant is currently on community supervision. Is there an agreement for a bond?
Yeah.
All right, and state what is the agreement?
The agreement is to set the individual bond at $20,000. It was previously set at $15,000, previous to, the case. But we're also requesting that ignition unlock be, installed on a vehicle, or if she's driving at all, for that matter.
All right.
That is the agreement, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear affirm? the
Oh, she can't, Your Honor, because of the,
Oh, that's okay. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, state your name for the record.
April Diaz.
I'm not talking about now. I'm going to talk to you and ask you questions about in the past because I don't want to interfere with whatever defenses you may have with regards to the motion to revoke. So in the past, have you had any type of drug or alcohol issues?
No drug issues. I have, I've drinking alcohol, obviously, and taken necessary classes, A as well. Just this past year, though, I did stop taking and going to AA.
All right. The court is going to set your bond at $20,000. There's to be ignition interlock on all accessible vehicles. There's to be no driving, and there's to be 120 sober meetings in 120 days. Is there anything with regards to the bond amount? Any other issues, state defense?
no, Your Honor. I've spoken to Satellite this morning. They are prepared to take her if I could be able to walk her down to Satellite.
Oh, the deputies will have to do that.
Oh, okay.
All right, so with regards to the motion to revoke, Ms. Ferguson, I need a contested hearing date in 20 days.
Oh, Your Honor, there, as far as discovery, it's a Bell County case, her new DWI, and they're very slow in that county as far as felonies and discovery.
I'm sure somebody can get a police report from Bell County. We'll see where we are.
Okay, yeah.
All right, February 25th,
We have the police report, it's just other issues, but yeah, no
okay,
problem.
for a contested hearing. If you'll make sure she has a copy of the reset form.
The situation has escalated dramatically. The judge has just set a new higher bond of $20,000 and laid out even more stringent conditions, including an ignition interlock and a staggering 120 sober meetings in 120 days. But the real danger here is the motion to revoke. The state is officially trying to revoke her probation from the previous case because of this new DWI charge out of Bell County. This means the 4-year suspended prison sentence she just received is no longer suspended. It's hanging directly over her head. If the judge finds that she did in fact violate her probation by getting arrested again, she could be sent directly to prison to serve that time. Her lawyer is already trying to delay the hearing, citing a key witness, her husband, who is on a special military mission and unavailable. The legal maneuvering is frantic because the stakes have never been higher.
Then if you'll speak to the deputies, they'll make sure that she is taken downstairs.
Oh, thank you, Your Honor. Appreciate you.
It is 2021, 23. Do you know?
It's a boy.
Oh, okay. Because
whatever.
I was gonna say you could name it after your travel buddy.
Yeah, well, we might do Alexander Gael Faugs, we'll see. I
Okay.
tried to do like a really really English name like Alistair, but my wife said no. No,
Okay,
Alistair.
I'm with her with Alistair. People would say, where is this coming from?
Exactly, so Alexander it might be. So we have Alessandra, she's about to be 5, and then Alexander, so.
Oh, that'll be awesome. All right, so
This is a move of pure desperation to convince the judge to delay the hearing and show that she's serious about sobriety. The defense makes an extraordinary offer. April will voluntarily wear a Scram device. That's a secure continuous remote alcohol monitor, an ankle bracelet that tests for alcohol consumption through the skin 24/7. But as the discussion unfolds, the judge uncovers a glaring contradiction. A probation officer notes that one of Diaz's original conditions was no driving period. The judge latches onto this. How could she have an ignition interlock, a device that allows you to drive, installed on her car if she wasn't supposed to be driving in the first place? Suddenly, the defendant is caught in a logic trap, stammering about her son-in-law taking her. The judge's patience is clearly wearing thin as she zeroes in on what appears to be yet another violation.
On this case,
This is our first true setting, Judge.
Mhm.
We came in, I think, last week or the week before to just get the bond set.
mhm.
We've been in discussion with the state today in regards to Ms. Diaz's case. At this time, it looks like it's gonna be a contested hearing.
And there it is. The gavel falls on a final, uncompromising set of rules. The judge accepts the defense's offer and orders the scram device, but she also doubles down on the no driving condition until further notice. The judge has drawn a hard line in the sand. There will be no more excuses and no more gray areas. If April Diaz wants to drive, or if she wants the alcohol monitoring bracelet removed, she will have to file a formal motion and convince this judge all over again. After a day that saw her sentenced for a felony, arrested on a warrant, and confronted about her probation conditions, April Diaz walks away on the tightest possible leash. Her 4-year prison sentence looms, and her future now depends on a contested hearing and her ability to make perfect choices. What do you think of the judge's final decision? Let us know in the comments, and subscribe for more in-depth courtroom breakdowns.
The only thing is that Ms. Diaz spoke with her husband yesterday. He's in the military and his home base is up in Seattle. But he gets deployed on special missions and things like that. So she spoke to him yesterday. He won't be available until May 8th. He can be available May 9th for Zoom or in person, Your Honor.
What, is he a witness?
I'd like to have him as a witness, yes. Ms. Diaz currently lives up by
In Fort Cavazos, Colleen.
in Killeen, Your Honor, with her son. So she made the choice to remain so her son could not get uprooted during high school. So she lives here, doesn't have support here. So her only real family support is her husband, who's out on a special mission. But he will be back in May, and to make the court feel comfortable and safe about possibly granting our request to hold that MTR contested hearing until May 8th or May 9th. My client's currently out on bond. She hasn't had any issues. She currently has an interlock in her car, but she's willing to add a scram to her body, Judge, just so that puts you at ease, and also add zero tolerance to her bond conditions if she tests positive.
No, we're gonna have the contested hearing sooner than that. So the contested hearing is going to be in March. I'll allow you all to pick your March date for a contested hearing. What date?
Can I get back to you, Judge? I'll try to see if we can maybe find some way to contact her husband to see if he can be available. She told her yesterday that he couldn't be, but maybe we can find some way. If I could just maybe have a few days to come back to you with a date.
All right, I tell you what date I'm gonna put it on. I'm gonna put it on probation. What dates? Tuesdays or Thursdays? All right, so we'll put this for March 25th.
Okay, Judge. Yeah, we'll try to
All
see
right.
if we can do what we can do on that.
All right, thank you so much. Once you sign the reset. All right, so counsel, you on this side. So State, you're withdrawing this?
Yes, Judge.
All right, and what is happening with the underlying case?
In Bell County, and so my understanding is pre-indictment over there, and they're planning to file their case. I just don't have time for that.
That's correct, Your Honor. She's on strict pre-indictment, pre-trial conditions.
All right. All right, Ms. Abrams. Of course, I'm not taking the number one is true because y'all are withdrawing it, but what are we gonna do as far as conditions here?
She is on interlock. Sorry, no, she's on interlock for Bell County.
It's
Okay, she's saying for Bear, but it is a Bell County condition of your pretrial. So she is on monitor, Your Honor. But I did let the state know that, you know, my client's not opposed just to scram for showing the court that she is serious about her change in behavior. So if the court is so inclined to order her for scram for maybe we offered the state 4 months before the MTR was withdrawn, just to show the court and the state that we were serious about this behavior change.
So Judge, when I'm looking at the conditions for Bear County as far as her probation is concerned. I don't show that the ignition interlock is still installed. We did have a removal that was completed back in 2023.
Well,
So, I would have to get more information on that.
and part of her conditions that I see here, unless they've changed, was that there was to be no driving. So allegedly, somebody's driving when they're not supposed to be driving.
Yes, ma'am. I did speak with the people in Satellite and they let me know about those conditions and as to why it said the other, but I had my son-in-law go and take me to get the ignition interlock into the car. I haven't been driving. I work remote.
Oh, well, this is the thing. I'm just telling everybody. My conditions, unless they've changed, was no driving. No, that was in place beginning February 6th, I think. February 6th. It was agreed $20,000 bond. Oh, you know what is a condition as bond?
Oh, that's what the confusion is, Your Honor. So it's
Yeah.
not part of her, yes, that's correct. So, and my client hasn't been driving, she works from home, but she's been blowing, that's correct.
All right, so alternate main conditions to include probation, you said scram?
Yes.
All right, I'm gonna order then scram, and there's to be no driving.
No driving to continue, Your Honor,
Yes,
for, how long?
until further notice. If she wants to drive, then you all will need to come back here and file a motion and ask the court to consider her to drive. If you all want scram removed, you have to come back here, file a motion, and we can hear whether or not scram should be removed.
In 4 months, would you feel that's enough time to come back to, Your Honor, potentially?
Sure.
Okay,
Okay.
thank you, Your Honor.
All right. Is there anything else? All right. And I've signed the motion and you need to make sure you're on time for court. All right. Thank you.
Judge.
Thank you for dressing appropriately.